In today's world, it is not uncommon for a notary, say in Germany, to be faced with clients who married in Romania and lived in Italy for a number of years before settling in Germany. A notary in Spain could be involved in a sale of an apartment to two persons from Mexico who concluded a civil partnership there. A Dutch notary advising two Dutch citizens about their assets could find out that one of the spouses owned an immovable in Italy. In other words, notaries are involved in many situations which concern more than one country. Within the EU, these cross-border situations may be even more common, since EU citizens benefit from the freedom to move from one member state to the other. In all these situations, the notary needs to determine what is the exact status of the assets of the spouses or partners. This may be relevant when one of the spouses wants to buy a house or take out a loan, but also when the spouses divorce or when one of them passes away. Every notary dealing with marital assets or the assets of partners needs to be aware of the fact that states have different views on the legal framework for the management and the splitting of assets among spouses or partners. In many countries, the spouses and partners may define by contract how their assets will be dealt with. This possibility, granted to spouses and partners to regulate their relationship by contract, may be more limited in some states than in others. In addition, the rules applicable by default to family assets may also be different. They may be inspired by the wish to guarantee a fair amount of solidarity among spouses or partners, or, on the contrary, by the concern to preserve the financial independence of the spouses. All these factors, taken together, underline the need to have clarity and certainty on the cross-border aspects of the assets of spouses and partners. In 2016, the EU adopted two regulations dealing with the cross-border aspects of family assets. The first regulation addresses legal issues arising between the spouses. The second regulation deals specifically with the assets of partners. These two regulations have been drafted in parallel, and they include, to a very large extent, similar provisions. On a few key issues, the solutions of the two regulations differ, however. The regulations provide an answer to the key questions which arise when notaries deal with the assets of cross-border couples. In the first place, the two regulations outline in which circumstances the courts of the member states may claim jurisdiction in cross-border disputes. Now, these rules are not primarily addressed to notaries, but they remain relevant because a notary may be involved in a case in which a dispute arises. The regulations also include a number of conflict of laws rules, that is, rules which determine which law applies in a cross-border situation. These rules play a very important role when a notary is called to assist spouses or partners whose situation is linked to several countries. The main principle of the regulations is that spouses and partners may decide which law applies to their relationships. They may, in other words, make a choice of law, albeit within certain limits. If the spouses or partners fail to make a choice of law, the regulations provide default rules. These rules are different for partners and for spouses. The regulations also provide a number of rules which facilitate the mutual recognition among member states of court decisions. If a dispute among spouses or partners has been finally settled by a court in a member state, this decision may also be relied on in the other member states. And importantly for notaries, these rules also apply to authentic acts, giving them a real cross-border dimension. The regulations are important for the activity of all notaries in member states. All notaries working in a member state should have a good understanding of the main rules of the two regulations to advise clients to their best interests.